And now the judges can introduce themselves.
Good morning and welcome to the We the People competition. I say good morning because I know you're in Arizona, it's still morning, and one of our judges is in the Pacific time zone too, where it's morning, but I'm in Colorado where it's mountain time and it's now afternoon, and our third judge is in Chicago where it's central time. So we have three different time zones for our judges for you today. My name is Dan Taubman, and I'm a senior judge on the Colorado Court of Appeals in Denver, Colorado, and I'll ask the other two judges to introduce themselves.
Hi, my name is Ben Glickman. I work for the California Attorney General's office. I'm also an alumnus of this program. I was on a national championship team back in '95. And I also lived in Phoenix for a short time and judged We the People there back in 2006. So,
my name is Ali Khan. I am an attorney in Chicago. Like Ben, I too am an alum of the program back in 1998, and we did not win the national championship and finish in the top 10 from the state of Illinois. So, congratulations for being here, guys. I know it's not always easy to get here, so great job.
And now could you introduce yourselves to us, please?
Well, good morning and good afternoon. My name is James Driscoll. I'm a two-time speech and debate national qualifier, and I'm also my school's graduation speaker.
Hi, my name is Laura Castro, and I'm a member of the Mayor's Youth Committee.
Hi, my name is Tessa Jagoda, and along with We the People, I'm a team officer for my school's Model United Nations team. And our coaches are Miss Lindblom and Miss Litzenberger.
What school are you guys?
We're from Mountain View.
And where is Mountain View?
It's in Mesa.
Oh,
right
okay, good. Thank you. We're going to ask you today question one, and I'll read the question, and then we'll hear your opening statement and then have a chance to ask you some questions and conclude with some feedback. I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review? You may begin.
A balance is made of three fundamental parts: the left scale, the right scale, and the vertical post in the middle. A court is similar to a scale, wherein each party competes to tip the scales of justice in its favor, while the judge represents the neutral post in the middle.
So when the Supreme Court has used judicial review to expand federal supremacy, it has tipped the scale of sovereignty away from the states. In doing so, the court has created an imbalance of power, overstepping its constitutional authority and its role as the neutral post. Therefore, Congress must recalibrate the scale.
Article 3 does not explicitly grant the power of judicial review, yet Federalist 78 implies that the court has the power to ensure Congress does not violate the Constitution. 1803 Marbury v. Madison solidified judicial review to decide constitutionality of federal laws and strike down acts of Congress.
While the court did not strike down another federal law until 1857 Dred Scott v. Sanford, it did strike down state laws, beginning with 1810 Fletcher v. Peck. 1816 Martin v. Hunter-Lacey expanded judicial review to state court decisions, and 1821 Cohen v. Virginia applied federal jurisdiction to review state criminal proceedings. Thus, the scales tipped towards the supremacy of the judiciary.
And as states have infringed upon individual liberties, the court has used the 14th Amendment's due process in equal protection incorporation to limit the scope of state legislative powers.
Consider 1958 Cooper v. Aaron, which invalidated actions of the Arkansas legislature, which undermined 1954 Brown v. Board of Education's equal protection ruling. The Cooper decision broadened judicial review to all state actions, placing supremacy in federal judicial interpretations.
And since the federal judiciary can overturn legislation passed by popularly elected officials, judicial review is a counter-majoritarian practice. The founders intentionally created an independent judiciary removed from the influence of the popular majority, free to make fair decisions based solely on constitutionality and federal statutes.
Article 3, Section 1 grants federal judges lifetime tenure, and Article 2, Section 2 grants the president judicial appointments with the advice and consent of the Senate. Federalist 78 asserts an independent judiciary is peculiarly essential to a limited constitution because it secures individual liberties without bending the Constitution to popular will.
To exemplify, 1942 Skinner v. Oklahoma struck down Oklahoma's Habitual Criminal Sterilization Act because it violated the equal protection and due process clauses. Even though the state legislature approved the act, it violated Skinner's fundamental liberty. So yes, the Supreme Court is counter-majoritarian and its independence remains essential in upholding the rights of the people.
But since substantive due process has enabled the court to broaden its constitutional interpretation and to exercise near legislative powers, Congress ought to have an override of judicial review. 1905 Lochner v. New York overrode state labor regulations, formally establishing the freedom of contract. However, Justice Holmes's dissent explains that the Constitution does not advance an economic theory and that individual labor regulation should be left to the state legislatures.
This is an example of judicial activism in which the court decided public policy, a legislative power, not a judicial one. Similarly, 2010 Citizens United v. FEC controversially defined corporations as people and shifted the scope of the First Amendment to include campaign financing. Since Marbury, the court has continually expanded its power over federal and state decisions.
So Congress should be able to override the judicial review decisions made by the court with a 2/3 majority of both houses. However, this override should not extend to suspect classification cases to protect the rights of minorities. And because it's difficult to overturn court decisions either by constitutional amendment or by Supreme Court reversal, it becomes increasingly important to check the court.
An impartial third party, a neutral post, is an important factor in ensuring balanced judicial decisions. Thus, the Supreme Court cannot act independent of its intended role as a mediator. It must ensure objectivity for the scales of justice to endure.
Thank you for your opening statement. So let me pursue your theme that the Supreme, as I understand it, that the Supreme Court has exercised more power than it should, and that it should, that Congress or state legislatures should have the power to override Supreme Court decisions. What would be the authority for Congress to override a decision of the Supreme Court?
Well, the authority is found in Article 3, Section 2, wherein it declares that Congress can create inferior courts, and that establishes like a connection between Congress and the legislature. And if they can legislate the judicial branch, they can have an override of judicial branch, such as is with Israel's Knesset.
Is there any specific provision in the Constitution that says that Congress can override a Supreme Court decision?
That is not specifically mentioned in the Constitution.
No, which is why we are proposing that we should have an override, because there are times where the Supreme Court has had power over individual liberty, such as Brutus 15 states that the judicial branch has complete power because no one can control their decisions or correct their errors. For example, 1926 Buck v. Bell upheld the forced sterilization of those with intellectual disabilities. And so we are proposing a legislative override in situations where the Supreme Court has made a mistake.
Additionally, Brutus 11 warned against the supremacy of the federal judiciary, so we can see that this congressional override would provide as a check for the judiciary so that the power of the judiciary doesn't overstep its original authority.
Just to continue that line of questioning, Laura, I think correct if I'm wrong, you just said that the congressional override should be used in terms of when the court has made a quote unquote mistake, correct? I would ask, who determines that something is a mistake? If that answer to that question is Congress, what is A, the point of having the court? B, doesn't that just essentially, I don't want to say eviscerate, that's perhaps too strong a word, but doesn't that just totally throw the balance of powers out of whack and basically make Congress just extremely powerful, kind of throwing everything out of line?
Well, in our proposition, it would be a 2/3 majority which we have seen in Article 5 of the Constitution's amendment process. And this override has also been seen in Israel, and they actually have a simple majority, and it has only been used one time in the Knesset, and it also has a 4-year sunset provision where they revisit and suggest if they should uphold that decision or return it back to the original decision by the court.
And the fears of disrupting checks and balances are unfounded because the 2/3 majority, that takes a whole lot of coalition building within Congress in order to actually meet that threshold. Laura talks about Article 5, and that 2/3 majority in Article 5, that threshold has only been met 31 times in the history of our nation. So this wouldn't be a disruption on checks and balances. Court decisions would still go through. There is a high enough threshold to retain that independence.
And to address your point,
I want to take this question a little bit further. So in your prepared remarks, you said that the override would not apply to cases involving suspect classifications. Who decides what's a suspect classification? And couldn't Congress just disagree that these are not discrete and insular minorities?
well, we propose a two-step process for this congressional override in which a body such as Biden's proposing currently, a congressional commission that would determine the validity of Supreme Court rulings. And so we would use this body to determine the validity of Supreme Court rulings and whether or not they are in alignment with constitutional interpretation and application. And then it would move on to the floor, to which it would get a 2/3 majority vote. So in that way, it would that body would determine whether or not.
And we've never implied that Congress has the power of suspect classification. That is a Supreme Court ruling, such as the footnote 4 of US v. Caroline products, wherein it said that it's the role of the court in order to explain what suspect classifications are.
Right, but what you're talking about is Congress being able to override Supreme Court decisions. So why couldn't they have overridden footnote 4? Or why couldn't they in the future determine that no, homosexuality is not a suspect classification, or transgender folks are not a suspect classification, or minors, or whatever it is? Couldn't the override essentially swallow the exception you're putting in there to protect minorities?
No, it couldn't. And there's a pretty basic constitutional protection of this under Article 3, Section 2, wherein it grants the judicial power arising under controversies between parties. So the judicial power of the definition of suspect classification is found within court cases, which we say this provision cannot overturn.
Wait, can you explain that again?
That the judicial power is vested in controversies arising between parties or an original jurisdiction with the Supreme Court.
Right.
So therefore, the Supreme Court has the power in controversies to define what suspect classification is, right? They have strict scrutiny tests.
But
And
if
so
a supermajority determines that they're wrong, that they've made a mistake, doesn't your congressional override allow them to change, Congress to change what is considered a suspect classification?
no, because if it's within suspect classification, they cannot touch that provision whatsoever. Right? Ours is
Is that circular? Because the court can say X, Y, Z is suspect classification. Congress says, no, it's not. Now, where do you stand?
Well, like Nicholas Stephanopoulos, like he's a Harvard professor and of law, and he explains that this provision still would not accept to the legislature. We are advancing a theory, and the way that like would play out in the legislature is precisely the theory.
So let me ask you a question to follow up on the questions we've been asking you. Do you think that the Supreme Court should be involved in deciding politically controversial cases in areas such as same-sex marriage, abortion, and gerrymandering?
I believe that if there is a clear interference with the Constitution and constitutional statutes, that the court should be able to determine the cases on that basis, because I think that although courts should be, or although judges should practice judicial modesty and that they only interpret the law on cases that are violating the Constitution, with a dynamically changing society, it is the role of the courts to adapt to our modern society and be able to interpret it as in comparison to how it was originally founded.
Is the counter-majoritarian difficulty, is it anti-democratic, or does it promote democracy, or neither?
It definitely is it is anti-democratic. However, in Article 2, Section 2, the president appoints the judges, and the Senate has the,
You can finish your thought.
they approve those judges that are on the court. And so since those branches, we do elect those officials, it is still democratic.
Okay, your time is up. Thank you. Let's show our appreciation for the team.
And now the
So
judges have some feedback.
let me start off by sharing some comments. You presented an unusual and novel approach to dealing with judicial review. And I think it's thought-provoking. One of the things that you might have distinguished was the difference between the Supreme Court ruling on legislative issues and constitutional issues, because legislative issues right now can be addressed by Congress or by a state legislature just passing a new law after the Supreme Court rules and in light of the Supreme Court's ruling. With regard to constitutional issues, I don't think that your proposal could be implemented unless it were done through a constitutional amendment under Article 5, which you were focusing on. And if that were to be realized, I think it would call into question the whole idea of Marbury v. Madison and Federalist 78, which you mentioned that the Supreme Court has the authority to say what the law is. So you would be changing that in a significant way if your policy were adopted. Going back to your opening statement, I do like the fact that you mentioned Marbury v. Madison, the Federalist 78, and various cases like the Dred Scott and McCulloch versus Maryland and Cooper v. Aaron. I wasn't sure from your mentioning of the Lochner case whether your view was that we should go back to the Lochner era in terms of interpreting the due process clause of the Constitution. But I think I'm glad that you mentioned that case. In responding to our questions, we had a vigorous conversation. That's always one of the goals of We the People, to engage the judges in thought-provoking issues, and you certainly have raised, as I mentioned, a thought-provoking proposal, and so I think you deserve credit for that. Whether it would have a chance of being implemented is a different question, but good job for your thoughtfulness and creativity.
Thank you.
One thing I wanted to add is, well, first of all, great job, guys. I know it's not always easy, so congratulations for being a great job. I think my colleague covered a lot of what I wanted to say, and that I think we all want to say. But the one thing that I want to point out is we really put you under fire there with some of the free response questions, and we may not always agree with what you said, but I appreciate your engagement and you're willing to push back and you're willing to at least defend your position and essentially not, for lack of a better phrase, not panic under pressure. So I just wanted to commend you guys for that. So great job.
Yeah, I think we're going to need to postpone the next hearing so I can continue to berate you about the congressional override provision. So it was a fun conversation. It's an interesting idea, and I'm not sure we ever fully got to where we were talking about the same thing. So as soon as you said it in your prepared remarks, I was like, well, great. So then it's tyranny of the majority, right? The minority rights are done because the Congress will just override them. And then you immediately said, well, we're going to exclude suspect classifications from that. And I said, oh, great. So you are protecting minority rights. But as soon as you introduce that exception, right, you're going to open up the door to all kinds of games. The court is going to frame every one of its decisions in terms of suspect classification to avoid Congress overriding. And conversely, Congress is going to make every effort in its toolbox to say that, no, that doesn't involve a suspect classification. And so it's going to be this endless battle between the two to see who has the final word, right? And so I think that was kind of the interesting, like, real world complication that I was hoping we could talk about, and we did talk about it, and it was a lot of fun. So I would just encourage you to think about that some more. But I really did appreciate that you had the carve out for suspect classification, because it showed that you had thought about what the problem might be if Congress could just override any decision. Finally, on my last question about, is the counter-majoritarian problem anti-democratic? So I think you're right. It's anti-democratic in the sense that it overrides a majority enacted legislation. There are legal scholars who would say that it's actually promotes democracy because it's addressing those discrete and insular minorities who are outside of the political process, right? The purpose of judicial review is to protect those groups, those suspect classes that can't otherwise get legislation enacted and enjoy the rights under the Constitution. So I think there is the argument that it's counter-majoritarian, but that's like a feature, not a bug, right? And I think you were getting at that a bit in your prepared remarks. So bottom line is, I really enjoyed our conversation. I wish we could talk about it all day. So very nice job, and best of luck the rest of the weekend.
Thank you.
Thank you.